Guys, welcome back to my channel. For today's video, I wanted to talk about self-help because I'm looking at legal terms, a dictionary, and everything else. So, in the legal rights, you have a right. You guys know this, right? You do have a right in a constitutional amendment of a right to talk about your own freedom of speech. Do you understand this? Because that is your right of justice. So, of course, you guys, an individual resorts to self-help when they retrieve property found under the unauthorized control of another person, are simply using sandbags and ditches to protect land from being flooded. You do have a right of self-help. You do realize this, right? Because the legal system places varied degrees of limitations on self-help, and laws vary widely among different jurisdictions. Often self-help will be allowed as long as no law is broken, and no breach of the peace, of course, is likely to occur. Also, the usual limit on the liability of actions of an agent will not apply. If one used an agent such as independent contractor to perform the self-help action, the principal will be held strictly liable if it goes wrong. Courts will often place stricter limitations on repossessions of certain types of merchandise and on evidence of tenants. Creditors and landlords who resort to self-help in such situations are prone to tort liability and in some jurisdictions to criminal liability. The lack of judicial remedy, if in loose, can often refer to individuals taking the law into their own hands. Usually, law violence or other illegal behavior. It can lead to factions involving around the parties and also to the bar civil conflict. So basically, long story short, make it certain simple that you are still having to follow law as proper adequate acknowledgments. And of course, that's just how the law goes, because that's just a United States citizen or a permanent resident. You still have to take on the pronunciation of the legal atmosphere because, of course, I'm a legal coach and I'm a criminal legal coach too. So, of course, because I'm Nefertiti. So, of course, I take on the broader horizon of my justice and my injustice standpoint. Why? Because I have a probation officer that I am talking to also. So, of course, she overlooks on the idea of what's going on with me and everything else too. So she tells me the proper acknowledgments, and then she tells me the feedback that she needs to persuade me with, so that way I could take into the account of reasonable accountability about who I am and how I have to come out every day with everyday thinking. Because now I have to think about the whole humanity of crisis sometimes too. And of course, the right of justice is to actually know that I'm working with a team versus myself with all these confusions on my mind. Because people want to play black and white, and then people want to play white and black. And then those instruments of disrespectfulness, it's not like me because obviously I'm grown, and obviously this is the whole 21st century where everybody colored mixed in is so strong. So this was a crisis time to really actually understand more justice behind it. So like I said, it's usually through violence or other illegal behavior. It can lead to factions forming around the disparate parties and also to the broader civil conflict. Historically, self-help has been regarded as the recourse for injured parties when no courts are available that will accept jurisdictions. The dangers of self-help books are often advanced as an argument against allowing a situation to develop in which people feel they have no juridical path to a remedy, or that the courts are too corrupt to render just a decision, and as the main reason why imperative courts are established in the first place. California has recognized the dangers of self-help. Evictions by landlords, in which tenants and landlords and innocent bystanders might be injured or killed as a result of self-help evictions. Due to a heavy case, landlords have civil litigants can be required to wait months or years for a trial date. The state of California gives landlord tenants cases priority over all other cases except for criminal trials and trials where the plaintiff The infant or defendant is over 70 years of age. So this is just the lack of judicial remedy, the degree of everything of limitations. The court will often place stricter limits of repossession of certain types of merchandise and on evictions of tenants. Creditors and landlords who resort to self-help in such situation are prone to tort liability and in some jurisdictions to criminal liability. Because you got to understand and you got to take an acknowledgement of legal. Because, of course, everything that we do illegally and illegal justice has to be in common practice of what you did in the black and white picture of legal. Because, obviously, if someone was trying to hurt you and someone was trying to damage you, what is the proper use of damage that you have to do? Self-defend yourself, right? Is that a right of justice or is that a wrong prosecution of justice? Because that's what I would want to understand, too. Because if someone's trying to hurt me, what would be the right of my justice to hurt someone that was trying to hurt me, right? Or would that be just disrespectful of just common justice, the proper use of justice? Because obviously, isn't that what justice is supposed to tell you? If someone's trying to hurt you, stand your ground. Because obviously, your life matters, just like you have to be here too. Because no one else has to feel like, oh, our life doesn't matter. So, of course, um, there are just some other laws. It's about your responsibility, closing arguments. You see, good faith, be a good subordinate. Good faith is human inactions and sincere intentions to be fair, open, and honest, regardless of the outcomes of interactions. While some Latin phrases lose their literal meaning over the centuries, this is not the case where, and porque me mena, I'm Mexican, so I'm Mexican also, so I have good faith in my subordinates because of course, it's about the right of justice upon it. And remember, I'm not a active attorney at law. I'm a legal coach at law because I like to coach on the law of privilege because law has the documentary fact-finding evidence of law because law is by an attorney of law. I'm a legal coach working with my attorneys. Do you see? I work with healthcare, I work with federal care, I work with all specialties. That's as a mark of my responsibility as a good supporting. That's a good faith of measures. So yeah, the cause of action. Okay, the jurisdictions of subject and manner, the federal question, the supplemental removal, personal plea, a cause of a case, a cause of action in law, and is a set of facts significant to justify a right to sustain, to obtain money, property, or the enforcement of a right against another party. The term also refers to the legal theory upon which a plaintiff brings suits such as a breach of contract or battery or false negligence. Negligence is negligence. Porque se me miento negligence, like this negligence. Negligence. You see, I can't say it the best way. I'm still trying. It's like negligence. It's negligence. You see, negligence. Negligence, because I have a wisp, you guys, because I have so many different fractions of who I am. So, of course, negligence is just the biggest statue of negligence. So, long story short, this is just your wrongful responsibility if you do not understand legal actions and know how to actually be a good civilian and be a good civilian because obviously that's what the promissory note is, you see, because obviously the promise to someone to do or not to do something as a noun promise means a declaration assuming that one will not do something. It means to commit oneself by a promise to do or give. It can also mean a capacity for good similar to a value that is be recognized in the near future. So yeah, you guys, so of course, both a oath and our affirmation can be a promise. One special kind of promise is a vow. Exactly. So I vow to be the best I could be. I vow to be the best person that I could be. I vow to actually let our community lift ourselves up to really be the best support that we can have and to be the best support that we could be, because that's a promissory note. Having good morning in your life and actually having a good day is in the best supporting of being a promissory note, so that you understand. Having a good night is a good promissory that you know it's another day ahead. Of course, it's the promise that's kept, not someone's mindset of a promise declaration that nobody could have a promise so stronger than I, because that's a promise that is kept, because I am here. And that is the promissory note that we will still survive and we will still move forward in life, because it's a promissory note that in bad times taught us today what we need to know today to move forward in the future, because obviously that's a promissory note. You see, that's a promissory note, okay? Because we now know the value of ourselves and we know the value of what we're working for ourselves for, because we want to have a good note in our measures to feel happiness too. So, of course, I'm a legal secretary, you guys. Of course, you guys. This is about your responsibility for pain and suffering. Of course, let's look into responsibility. So, collective responsibility, corporate social responsibility, deputy, legal liability, legal obligations, legal responsibility, media responsibility, moral responsibility, personal responsibility, professional responsibility. There's a lot of responsibilities that you have to understand. A responsibility of substance in spiritual and personal growth context, okay? Responsibility for the Holocaust, you have to understand, because obviously this is a lot of responsibility that you have to apply yourself with. Responsibility and be a responsible one. Of course, pain and suffering, the physical and emotional stress caused from an injury, and pain and suffering, which, there was a lot of pain in this country that we went through. But there's a lot of best happiness from this country that we're seizing the opportunity with, too. So, some damages that might come under the category would be aches and temporary and permanent in liabilities or activities, potential shortening of life, depression, or scarring. When filing a lawsuit as a result of an injury, it's common to someone to seek money, both in compensation for actual money that is lost and for the pain and stress associated with the injury. Pain and suffering is part of a general damages section that claimants claim, and it is a element of compensatory non-economic damage. So non-economic damage that allows recovery for a mental aggression and or physical pain endured by the claimant as a result of injury for which the plaintiff seeks redress. Of course, you guys, when you work as a legal secretary like I do, that's why I work with my criminal justice secretary also, which is myself. But then remember, I have a probation officer who I would talk to too. I have a healthcare worker. I have a lot of different legal coachings that I work with also. Because I'm one legal coach, but there's not a legal coach just like me. Of course, it's sanctioned not to give the permissible acknowledgments of liability because it's the jurisdictions that it is, okay? So, of course, I'm a legal woman in Arizona. But, of course, as a legal woman, concernment goes, it's the best justice for you to know that. We're just like you and me, okay? We're just trying to find the best outreach for all our pain and our happiness also. So I hope this helps you guys as a legal woman. I hope this helps you. I'll see you guys in another video.